So what am I going to do?
Probably scroll down.
I need this. Huh? What is it? Do what?
And I saying probably no, it's still won't allow you to click into it.
Yeah.
That's weird. I mean, let Clement try for SPC.
Honorable D, good afternoon, DPP.
Good afternoon.
How are you, my lord? You may need to mute. We're hearing you're exposing to us that the technology is not your friend.
Yeah, and I have an assistant here that is
I-
not that's looking for another assistant.
It's not your friend either.
Oh my God. All right.
Yes, even your system. Oh. Yes. Thank you.
Yes, so please call him and tell him we are here. We are here.
Your issue?
No, I don't.
Let me check.
You have been in touch with him.
Chief Justice, you're unmuted. Good evening, everyone.
Is Justice Turner there?
Yes, he is. I'm seeing him on.
Right, thank you.
Thank you.
I'm muting.
Good afternoon, all. May I take mention of the Honorable Chief Justice, Justice of Appeal Turner, DPP, Justice Anthony Gruchot, Justice Luban Jackson, Chief Magistrate Hatman, Magistrate Salva, Magistrate Kemba, Mr. Mitchell Casey, Dr. Angela Brooks, Deputy DPP, and all other attorneys signed on. I wish to welcome this distinguished group to the Judicial Education Institute of the Turks and Caicos Islands seminar on an exposition of the Vulnerable Witnesses Ordinance with particular reference to special measures. This seminar is being presented by newly appointed Justice of Appeal, Bernard Turner. Permit me, please, to give a brief bio of Justice of Appeal Turner. Justice of Appeal Turner was appointed by His Excellency the Governor Nigel Dakin, CMG, as advised by the TCI Judicial Service Commission as a Justice of Appeal for the Turks and Caicos Islands from 1st May 2023 to 30th April 2028. His Lordship is a 1987 graduate of the Norman Manley Law School, Kingston, Jamaica, and has been a judge in the Supreme Court of the Commonwealth of the Bahamas since December of 2009. He was appointed a senior justice in the Bahamas in October of 2020. Prior to joining the judiciary of the Bahamas, Senior Justice Turner served as Crown Counsel in the Office of the Attorney General since 1988 and was appointed the Director of Public Prosecutions in 1999. He has extensive experience in criminal law and prosecution, having served as DPP for 10 years. He is presently the Senior Judge in the Criminal Division of the Supreme Court in the Bahamas and is experienced in the necessary measures for the protection of witnesses during a trial. Prior to joining the judiciary, His Lordship was also a trained anti-money laundering and combating the financing of terrorism examiner, a CFATF mutual examination, AML/CFT examiner and trainer, an IMF short-term consultant on assessing the quality and consistency of AML and CFT reports. The 2002 to 2004 chair of the Commonwealth Working Group on Asset Repatriation and the Bahamian designated expert on the Committee of Experts on the implementation of the Organization of American States Corruption Convention. His Lordship is the Chancellor of the Anglican Diocese of the Bahamas and the Turks and Caicos Islands. I now wish to hand you over formally to Justice of Appeal Turner, who will conduct this seminar. Justice of Appeal Turner.
Thank you very much, Mr. Moderator, and I will stand on your established protocol. I do apologize about coming in a minute late. I was actually on the Zoom link that was on the invitation, and I only, in checking when it didn't come on, I checked and found the email with the new Zoom link. So I do apologize about that. Madam Chief Justice, thank you again for inviting me to do this presentation. If I may be permitted to share my screen, and I would also like to give my regards to my fellow justices of the Court of Appeal, justices of the Supreme Court of the Turks and Caicos Islands, magistrates of the Turks and Caicos Islands, counsel and attorneys at law, ladies and gentlemen, good afternoon.
Good afternoon.
It is my distinct pleasure to be able to share on this subject of the Honorable Witnesses Ordinance, Chapter 216 of the Turks and Caicos Islands, which is, if I may say, a very comprehensive piece of legislation. In the Commonwealth of the Bahamas, the areas which are covered in this ordinance are found in 4 separate pieces of legislation. Some in the Evidence Act, some in the Criminal Procedure Code, a standalone Witness Anonymity Act, and located elsewhere within the statute laws of the Commonwealth of the Bahamas. I would like to, therefore, as indicated by the moderator, we'll be focusing on the special measures. I'll give a broad overview in respect to the ordinance itself. Now, the objective of the ordinance, as found indeed in the long title, is for the special measures directions in case of vulnerable and intimidated witnesses. That's to be found in Part 2, Sections 3 to 20. Also, the use of live link in criminal and civil proceedings, which is Parts 2 to 5, found in Sections 21 to 30. And then the admissibility and status of evidence by video recording, Part 6, that's Sections 31 and 32. And the protection of witnesses from cross-examination by accused persons, that's Part 7, Sections 33 to 39. The protection of complainants in proceedings for sexual offenses, that's Part 8, Sections 40 to 43. And finally, witness anonymity orders for Part 9, Sections 43 to 52. In respect of live links in criminal proceedings by witnesses, the Part 3 governs this subject, and in it, it's found that a witness may testify in essentially any proceedings with the legal. If the court is satisfied that it is in the interest of the efficient and effective administration of justice, and the Director of Public Prosecution indicates that suitable facilities exist. I had forgotten to welcome the Director of Prosecutions, and thank you for being present, sir. An application can be made on the motion of any party or on the court's own motion, and it may be withdrawn. Reasons must be provided for refusal to grant an application. In the Supreme Court, the jury must be given an evidential equal weight direction in respect of the evidence of a witness appearing by way of a live link. This, as I've indicated, is just a broad brush in respect of the other portions of the ordinance which exist. But my focus will be on the special measures. The next topic is live link by accused persons, and that's found in Part 4, Sections 24 to 27. And this is applicable when accused is under 18 years of age, and it assists him in participating effectively in the proceedings, having regard to his intellectual ability or social functioning, or he is over 18 years of age, but suffers from a mental disorder or other significant impairment of intelligence and social function. Again, reasons must be given for the grant or refusal of such an application. And the jury direction is also required in respect of the quality of the weight of the evidence, although it is by way of a live link. I won't touch at all on the part 5 of the ordinance, which is live link in civil proceedings. But I would note that there is, in addition to this ordinance, there is also the court live link remote participation ordinance, which passed and came into force 3 months after this ordinance, and seems to cover all criminal and civil matters, and indeed is a more permissive piece of legislation. As to the interaction between that legislation and the vulnerable witnesses legislation remains to be seen. Both of them is just several years old now. But there is provision in this ordinance for a live link to be used in civil proceedings. And I just note that. Part 6 deals with evidence by video recording. This is applicable in relation to any witness to the following offenses. A, offenses under parts 6, 8, and 9 of and 11 of the offenses against the person ordinance, and sections 5, 6, and 32(2) of the juveniles ordinance, and part 2 of the trafficking in persons prevention ordinance. Or in relation to kidnapping or false imprisonment, or any offense not otherwise captured above, which involves an assault on or injury or threat of injury to any person. The next section covered by the ordinance is the protection of witnesses from cross-examination by an accused in person. And that is part 7, sections 33 to 39. And this is applicable in relation to complainants in proceedings for sexual offenses and to protected witnesses, which are to say a child complainant or a child witness to an offense covered by the section, which is to say offenses under parts 6, 8, and 11 of the offenses against the person ordinance, sections 5, 6, and 32(2) of the juveniles ordinance, part 2 of the trafficking in persons prevention ordinance, or kidnapping or false imprisonment, any offense not otherwise captured above, which involves an assault or an injury of injury to any person. And in this part, a child is defined as any person under 18 years of age for the purposes of the offenses in paragraph A, and a person under 14 years of age for the purposes of the offenses listed in paragraphs B or C. And so the definition of child changes depending on the offense in this portion of the ordinance. Part 8 of the ordinance deals with protection of complainants in proceedings for sexual offenses. This is part 8, sections 40 to 42. And in relation to that ordinance, if that portion of the ordinance, if at any trial a person is charged with a sexual offense, then accepted the leave of the court, no evidence may be adduced and no question may be asked in cross-examination by or on behalf of an accused at the trial about any sexual behavior of the complainant. And this is a fairly common piece of legislation found throughout the Commonwealth Caribbean and indeed throughout the Commonwealth. Witness anonymity orders are found in sections 43 to 52, part 9 of the ordinance. Now, witness anonymity orders really could merit a lecture on their own. They are important pieces of legislation. We have had in the Commonwealth of the Bahamas witness anonymity and a Witness Anonymity Act since 2011, the Criminal Evidence Witness Anonymity Act of 2011, and it is used fairly frequently. So I'm just touching on this, but I would like to say that in respect of anonymity orders, it's important for the Department of Public Prosecutions, in particular, prosecutors generally, in making applications to recognize that not every matter in which a witness may wish to be anonymous is really a matter in which the witness will be able to be properly made anonymous. I say that because of the experiences that we have had in this jurisdiction in respect of anonymity orders. We have had orders made in respect of persons who, from the evidence, although it is redacted, it is clear that the witness would have been in close proximity to the accused person. Indeed, in one anonymous order we had, the witness spoke about, the redacted statement spoke about him having a conversation with the defendant. Now, his name and any details tending to identify him are redacted, but certainly from the circumstances of the matter itself, it would be clear to the accused person precisely who the witness is. We've also had anonymity applications in respect to persons. Again, in reading the statement, it's apparent that they were in a vehicle along with the accused person. Now, there are certainly matters in which I dealt with a murder trial in which there was an anonymous witness who testified in respect of his or her, because the voice was modulated and they were out of the courtroom. That was the context of the legislation, is the context of the legislation in the Bahamas. But he or she spoke about being walking along a road at 2 a.m. in the morning when they happened to see two persons running with a firearm. In that time, and they considered that the persons did not see them. And so they were the subject of an anonymous application, and an order was made, and they testified. And it would not have been apparent what their identity was due to the circumstances of the case itself. However, as I've said, in many other instances, we have seen anonymous witness applications in respect of persons that an accused person would easily be able to identify. Further, and this is of some concern, we have also had applications because in the legislation in the Bahamas, it is an offense to identify the anonymous witness, but we have had applications in matters in which there's an anonymous witness order, in which there's an affidavit filed by a named person who does not identify themselves as the anonymous witness. But from the circumstances of the case, it is fairly apparent that they are in fact the anonymous witness, withdrawing their testimony. So in other words, these persons who, when they may have been approached by the police and told that they would have they would be made anonymous, they would have been contacted, presumably, by persons and felt sufficiently threatened that they essentially withdrew their testimony, not identifying themselves as the anonymous witness, because those persons responsible for the production of the affidavits would appreciate the difficulties that they might be in if they were to identify the person as the anonymous witness, but nevertheless, they produce an affidavit in the known name of a person and present it to court as evidence that this person does not wish to testify, and that he didn't give the information which any statement may suggest that he gave. And so it's important to understand that it's not in every case, particularly in small societies like the Bahamas and like the Turks and Caicos Islands, that in many instances, you may have a witness who doesn't wish to be identified, but that effectively that witness may not be able to be an anonymous witness in respect of criminal proceedings without his being easily identified by the accused persons. But in respect of the ordinance, the relevant considerations for the making of an anonymity order include deciding whether conditions A to C in section 45 are met, and in that regard, the court must have regard to the following considerations: the general right of an accused in criminal proceedings to know the identity of a witness in the proceedings, which is an important consideration. That is a general right that has always existed. B, the extent to which the credibility of the witness concerned would be a relevant factor when the weight of his evidence comes to be assessed. And again, the defense would always be hampered because if they don't have any information as to who the witness is, they're not able to determine whether there are any credibility issues. So whether, for instance, the witness has an interest to serve or an axe to grind with the accused person. C, the evidence given by the witness might be the sole or the decisive evidence implicating the accused. In the case that I mentioned earlier, there was other evidence, but he was the only eyewitness, but the firearms were recovered and linked to the defendants and linked to the murder. We also completed last week another anonymous witness case in which the anonymous witness was the principal evidence of the prosecution. And in that instance, the defendant was convicted. D, whether the witness's evidence could be properly tested, whether on grounds of credibility or otherwise, I've mentioned that already, without his identity being disclosed. As I said, it's just a light brush in respect to the anonymity orders. E, whether there is any reason to believe that the witness, one, has a tendency to be dishonest, and again, without any information about the witness, it would be difficult for the defense to be able to put relevant questions to the witness. 2, whether the witness has any motive to be dishonest in the circumstances of the case. I've touched on that already. Having regard in particular to any previous convictions of the witness and to any relationship between the witness and the accused or any associates of the accused. F, whether it be reasonably practicable to protect the witness by any means other than by making a witness anonymity order. It comes back to what I've been discussing in respect of the fact that from the circumstances, the witness may be easily identified or at most be able to identify it as being one of only 2 possible persons. And in those circumstances, there are other steps which may need to be taken rather than seeking to make the witness anonymous, if in fact he could be identified anyhow without any information coming from his statement. And G, any such other matters the court may consider relevant. These are the things the court would consider when it's making an anonymous witness order. Now, we come back to the special measures directions in case of vulnerable witnesses or intimidated witnesses. Now, section 3 of the ordinance in respect of witness eligibility makes eligible for special measures directions being given any child witness, and that is to say any witness under 18 years of age, or if the court considers that the quality of the evidence may be impacted because the witness is a person who is suffering from a mental disorder, as defined by section 2 of the Mental Health Ordinance, or who otherwise has a significant impairment of intelligence and social functioning, or who is otherwise vulnerable, or who has a physical disability or disorder. And so under section 3 of the ordinance, any child witness is eligible for the full scope of special measures directions, which are found, and we'll come to those later. Any other person that may be impacted because of mental health disorder or a significant impairment, which is not a mental disorder as defined by the Mental Health Ordinance, but as determined by the court, that this person has a significant impairment of his intelligence or social functioning, or is otherwise vulnerable, or indeed any person who has a physical disability or disorder. So young people, children under the age of 18, persons suffering from a mental disorder, persons with that may not be, according to the Mental Health Ordinance, suffering from a mental disorder, but does have an impairment of their intelligence or social functioning skills, or somebody otherwise vulnerable within that context, or a person with a physical disability or disorder. Query how far that would go, but when we come to the measures, then you would see the thinking behind in respect to the issue of physical disabilities, persons, for instance, who are blind, or persons who may be sight impaired. These persons all come under Section 3 in respect of being eligible for special measures directions. Under Section 4 of the ordinance, a complainant in respect of a sexual offense is eligible for directions, or if the court is satisfied that the quality of evidence given by the witness is likely to be diminished by reason of fear or distress on the part of the witness in connection with testifying in the proceedings. And this is in respect of what one would call truly a vulnerable witness, a person who considers that from fear or from distress, a person who's not become an anonymous witness, and so therefore they feel that they can be identified, or they are identified, and they feel fear or distress from being a part of the proceedings as a witness. Such a person, if determined by the court to come within the criteria, is entitled to a degree of special measures. Now, how do we determine this? According to Section 4, subsection 2 of the ordinance, the nature and alleged circumstances of the offense to which the proceedings relate is a factor to be considered. The age of the witness, although as I've said, if the witness is under the age of 18, the witness falls within Section 3 of the ordinance, but you can still consider age even though the person is 18 or above. Consider that as one of the factors to determine whether an order should be made. And then such other matters as appear to the court to be relevant, namely, the social and cultural background and ethnic origin of the witness, the domestic and employment circumstances of the witness, and any religious beliefs or political opinions of the witness. D, any behavior towards the witness on the part of the accused or members of the family or associates of the accused. And oftentimes, if, for instance, the accused is in custody, you find witnesses complaining that somebody else is contacting them, or even the accused from prison by the use of cell phones, which they are not supposed to have, but which find them their way into penal institutions or remand institutions. And any other person who's likely to be an accused or a witness in the proceedings. Now, the Director of Public Prosecutions has an important part to play in the consideration of these applications, because unless the Director of Public Prosecutions has in place, let me just read it, unless the court has been notified by the Director of Public Prosecutions that arrangements may be made for implementing the measure in question which cover the witness and the proceedings, and the notice has not been withdrawn, the court shall not make the special measure available to the witness. And so the Director of Public Prosecutions, according to the ordinance, has to have in place measures so that indeed the court is able to make an order for a direction for special measures. And the governor also has a part to play, because the governor may vary the ordinance to affect a particular witness, or either by increasing available measures or by removing certain measures which were in place. According to Section 6 of the legislation, after determining the eligibility for assistance, the court then determines, by considering any views expressed by the witness, and whether the measure or measures might tend to inhibit such evidence being effectively tested by a party to the proceedings, whether any of the special measures or any combination of them would be likely to improve the quality of the evidence given by the witness. And if so, the court would give a direction for the measure or measures to be applied. A special measure direction, these are just the general provisions. A special measure direction is binding until the proceedings are determined by an acquittal, by a conviction, or otherwise are abandoned. That is the language of the ordinance, that it's abandoned. there is power to vary or discharge an ordinance, a special measure direction which is made. A special measures direction may be varied or discharged if it appears to the court in the interest of justice to do so, or on its own motion or on an application by a party to the proceedings. So the court itself may decide to discharge or vary a direction, or there may be an application by any of the parties to the proceedings for the variation or discharge of the direction. The court shall state in open court, and let me say too that according to the definition section in the ordinance, the court for the purposes of the legislation includes the Supreme Court, the Magistrates Court, and the Court of Appeal, except in relation to Part 5, which is in relation to the use of video link evidence in civil proceedings. And so in respect of vulnerable witnesses, not of much moment. So any court that makes an order must state in open court the reasons for giving or varying or refusing an application for, or for the variation or discharge of, or for discharging any special measures direction. If it is a court of summary jurisdiction, then the magistrate shall cause the reasons to be entered in the register of its proceedings. Under the legislation, there are special provisions which relate to child witnesses. Already said that in respect of any person who's a child witness for the purposes of Section 3, anyone under 18 years of age, is entitled to the full scope of special measures directions. But there is also provision in Section 8 relating to child witnesses. And it says that the primary rule in the case of a child witness is that the court shall give a special measures direction which complies with the following requirements. 1, it shall provide for any relevant recording to be admitted under Section 15. And 2, it shall provide for any evidence given by the witness in the proceedings which is not given by means of a video recording to be given by a live link in accordance with Section 12. We will come to Section 12. And so, Section 15 refers to video recording of an interview of the witness with the purpose of it being used as evidence in chief. And so the special provision is providing that in respect of a child, the evidence in chief should be recorded on video, and that be presented as the evidence in chief of the witness. And that if it is not done in that fashion, then that the witness would appear by way of a video link into the courtroom, not being physically present in the courtroom, but appearing by way of a video link. Now, there are limitations to the primary rule, which may result in the rule not applying. If as a result of that, the child testifies in court, then the court is still required to make a special direction as found in Section 11, and we will come to Section 11. And so even if the child doesn't testify by way of a video link or testifies on a video recording and actually comes into court, nevertheless, in relation to that, the child is still protected by Section 11, a special measures direction under Section 11. Section 8, subsection 8 indicates that if a child witness is an eligible witness only because he or she is a child, then the special measures will fall away at 18 years, unless he or she has begun to give evidence. For Section 9 of the ordinance, the provisions of Section 8 may also be extended to witnesses who have attained the age of 18. And so although, therefore, if you've started to testify, or if the court determines, you may in fact, the provisions of Section 8 protecting child witnesses may still be extended to persons who are above the age of 18 years of age, above the age of 18. In respect of sexual offenses, there are special provisions as well. They're found in section 10. And it says that the court shall give a special measures direction in relation to the complainant that provides for any video recording of the complainant's interview done with a view to being admitted into evidence to be received as the evidence in chief of the complainant. And so similarly to child witness, in respect of complainants in relation to sexual offenses and any other charge that is connected to the sexual offense that the defendant may be facing, that witness, complainant, provision is made for the evidence in chief to be video recorded. In relation to the magistrate's court, this provision does not apply. And if the child is complainant is under 18 years of age, this provision also does not apply. But remember, the child is otherwise protected from section 8 and also from section 3(1)(a), which gives him the full scope of special measures. Now, the special measures available to eligible witnesses. This is the focus of the discussion this afternoon. According to section 5, subsection 1, a witness who is eligible for assistance by virtue of section 3, that is to say, child witness, a person suffering from a mental disorder, a person who not suffering from a mental disorder, nevertheless has significant intellectual challenges or intellectual disabilities, and or persons suffering from a physical disability, those persons come in section 3. And any of those persons are entitled to the special measures directions made per sections 11 to 18. A witness who is eligible for assistance by virtue of section 4, that is to say, the witness who is, as I said earlier, the truly vulnerable witness, the witness who is in fear or distress at having to testify, that witness has the measures which are available pursuant to sections 11 to 16. So section 3 witnesses, eligible witnesses, have the full scope of special measures found in 11 to 18. Section 4 witnesses have the scope of protections, special measures found in sections 11 to 16. And what are those measures? Section 11, and did indicate we would come to this. This is in respect of even if a child witness is testifying, they're still entitled to this protection of being screened from the accused. And this section provides that the witness, while giving testimony in court, may be prevented by means of a screen or other arrangement from seeing the accused. The witness must, however, be able to see and be seen by the judge or the magistrate and the jury, if there is one in the Supreme Court, and by the attorneys acting in the proceedings. And so this is a screening in court. It is not an anonymous witness. The witness's voice is not modulated, as are the provisions in the anonymous witness sections that I touched on just very briefly. But the witness, the section itself says the witness cannot see the accused. And you would assume that the witness cannot see the accused cannot see the witness. But the arrangements must be made in the courtroom physically, so that whereas the witness and the accused cannot see each other, the judge, the magistrate, the jury, the attorneys, any interpreter or the person appointed, if it's an interpreter for language purposes, or if it's use court reporters, any other person, official who's functioning in the court for certain purposes, must be able to see the witness. As indicated, any other person having the authority to hear and to receive the evidence. And so limited screening to prevent the witness, and you would understand the reasoning behind that, the fair interpretation, the distress caused by the witness having to testify would be ameliorated to some extent by the witness not being able to see the accused person, so that if there is a concern that the accused person, by looking intently at the witness or in any other fashion, just being present, the accused may not be doing anything at all, absolutely nothing. But the witness, by the knowledge that this is a person in respect of whom something has taken place in relation to myself, may, from those circumstances on their own, feel sufficiently distressed that to see the person would impair their ability to testify clearly and articulately in relation to the matter, and therefore the strain prevents the witness from seeing the accused, and the accused concomitantly not being able to see the witness, and he too is protected from any allegations that he was glaring or staring too intently at the witness. So that is the first special measure in the ordinance, section 11, screening the witness from an accused person. The second measure is special measures evidence by video link, as found in section 12, and there are a number of provisions in section 12 as to the application for a live video link. I think we all know by now, pretty certain live video links have been used. Well, you know for a fact that they have been used extensively in the courts in the Turks and Caicos Islands, and it is simultaneous transmission of voice and images, so that the witness is able to see into the courtroom, the judge, the magistrate, the jury, the attorneys, the accused is able to see the person, wherever that person may be, by way of the live link, as it's referred to, the television camera, the monitor, that's the television monitor, or the monitor that is in the courtroom. That is a measure which is the standard measure now. And as I had indicated, there is the Court Live Link Remote Participation Ordinance, which came into effect on the 4th of January 2021, which makes for wide-scale use of live links for criminal and civil proceedings in the Turks and Caicos Islands. The next measure is the special measure for evidence to be given in private. This is found in section 13 of the ordinance. Now, a direction may provide for the exclusion from the court of persons of any description specified in the direction, but not the accused or his attorneys. And it's only given where the proceedings relate to a sexual offense, or it appears to the court that there are reasonable grounds for believing that any person other than the accused has sought or will seek to intimidate the witness in connection with testifying in the proceedings. In those circumstances, the evidence persons may be excluded from court. Now, this is in contrast to, and some would say is somewhat parallel to the provisions which again exist in a number of common jurisdictions, in which, in respect of sexual offenses, the court may limit the amount of persons in the courtroom, and obviously there are common standards, and this is in the Turks and Caicos Sexual Offences Act as well, which would ensure that, for instance, the identity of the virtual complainant in any sexual offences matter is not revealed, either by directly calling their name or by calling any other, providing any other information, or publicizing any other information, which would tend to identify the virtual complainant, extending in the incest cases, of course, to not identifying the accused person if the relationship alleged in the offense would tend to identify the virtual complainant. And so those cases in which there is an allegation of a father or a brother or anything of that nature, then all of those, none of that information is provided so that the virtual complainant, the alleged victim, is protected, not so much for the protection of the accused person, but his information is not provided so that the virtual complainant is not identified. So these proceedings relate to sexual offenses, or if it appears to the court that there are reasonable grounds for believing that any person other than the accused has sought or will seek to intimidate the witness in connection with testifying in the proceedings. And again, if I may say, it has been our experience, the unfortunate experience, that we have a high rate, in particular in relation to sexual offenses matters, but murders as well, of witnesses, even with some form of protection, with an order in respect to them testifying by way of live link, for instance, or some other order, of witnesses coming forward and withdrawing their testimony, filing affidavits. Indeed, we have had affidavits filed in relation to bail applications for persons who've been in custody for a week or 2 weeks. And there is an affidavit from the virtual complainant indicating that they are either withdrawing their testimony or that they never told the police the things which are contained in the statement being used as a reason why there's an assertion that it's cogent evidence, which would then be one aspect of why it is that the prosecution would be saying that the person should not be released on bail. So we have a high degree of, I wouldn't call it interference, that's a determination to be made, but there is a high incidence of witnesses withdrawing their testimony, which results in matters, in many instances, being discontinued by the prosecution, or there being an evidential failure in respect of the matter itself. In this regard as well, indicate that a few years ago, I had the experience of dealing with a murder case in which the principal evidence was from the twin brother of the deceased, who had identified the two persons who he asserted had shot his brother, standing right next to him. By the time that he came to court, he resiled from that testimony and said that he didn't see anybody and he never told the police the things which were contained in a statement. This is in relation to his twin brother, his identical twin, but nevertheless, the circumstances were such that and of course he said he didn't tell the police those things, that he didn't see anybody, and so maybe he didn't see anybody. But there was a statement which he resiled from and came to court and said that those things were not things which he had seen. And so it shows the degree of, perhaps, again, without drawing any conclusions, of witnesses changing their testimony. And some would say witness interference and or intimidation. But again, as I said, that is a matter to be determined. Court makes no determination on that unless there's evidence placed before it to make a decision. Another of these special measures, which just needs to be mentioned, but which has an impact, is the removal of wigs and gowns. And a number of persons feel that, of course, the judge and the lawyers being dressed in what some would refer to as colonial garb has the effect of intimidating witnesses who are not perhaps accustomed to being in that environment. And so there is provision in Section 14 as a special measure in respect to persons under Sections 3 and 4 for wigs and gowns to be removed. And counsel will be able to say whether this has happened or any judge of the Supreme Court, I suppose, as to whether this measure has been deployed in the Supreme Court in the Turks and Caicos Islands. Just say that in the Bahamas, gowns are still worn and bibs and collars, but except for ceremonial occasions, we no longer wear wigs in any matter, except, as I said, on ceremonial occasions. But that's section 14 of the Vulnerable Witnesses Ordinance. Section 15 is more substantive. It is the special measure of video recorded evidence in chief. And this section makes provision for a video recording of an interview of the witness to be admitted as evidence in chief of the witness. Now, if the court is of the opinion, having regard to all of the circumstances of the case, that it is in the interest of justice for the recording or a part of it that it should not be admitted, then that part of it may be excluded. But in this regard, the court shall consider whether any prejudice to the accused which might result from that part being admitted is outweighed by the desirability of showing the whole or substantially the whole of the recorded interview. And so provision is made, and obviously this takes some planning because the rules of evidence would apply to this video recorded evidence in chief. And so if there are leading questions or there's inadmissible evidence, you may very well have a situation in which there is a video recording of the evidence in chief, but in relation to it, there may be able to be objections as to some aspects of the evidence. And the court would then have to determine how it would treat with that, since it's a video recording of the evidence already. Related to section 15 is section 16. So there's a special measure as well in respect of the video recording of the cross-examination and the re-examination. And so where a video recording is admitted under section 15 of the evidence in chief, then the direction may also provide for any cross-examination of the witness and any re-examination of the witness to be recorded by means of a video recording. And for such a video recording to be admitted, so far as it relates to any such cross-examination or re-examination, as evidence of the witness under cross-examination or on re-examination, as the case may be. And so you have a video recording of the evidence in chief, and there's also provision for cross-examination to be video recorded and re-examination to be video recorded. And I would like to hear from any of the judges present as to whether this provision, section 16, sections 15 and 16, have been used in the courts in the Turks and Caicos Islands. We have similar provisions in the Bahamas, but so far as I am aware, we have not yet had any video recorded evidence in chief, either of a child or of a person in respect of whom an order has been made, being presented as the evidence in chief, and certainly no cross-examination or re-examination by way of a video recording. The special measures which have the widest usage are those which provide for the witness to appear by way of a video link into the courtroom without actually physically coming into the courtroom, and that is used extensively. And persons have testified from around the world in relation to matters in the courts in the Commonwealth of the Bahamas. So that's section 16 of the ordinance. Now, that is the last of the special measures which apply to persons who, in respect of whom an order has been made pursuant to section 4. Because as I said, and as the ordinance says, not because I said it, the ordinance says that in section 4, the special measures found in sections 11 to section 16 are available to persons in respect of whom a special measures direction has been made. Sections 17 and 18 are only applicable to the Section 3 eligible witnesses, that is to say again, the child witnesses under the age of 18, witnesses suffering from a mental disorder or intellectual impairment or physical impairment. And in relation to that, a person perhaps who's not able to speak, not the regular interpreter being used, but a sign language interpreter, for instance, this makes provision for evidence of the witness through an intermediary. It says that a special measures direction may provide for any examination of the witness, however, and wherever conducted, to be conducted through an intermediary. The function of an intermediary is to communicate, A, to the witness questions put to the witness, and B, to any person asking such questions, the answers given by the witness in reply to them, and to explain such questions or answers so far as necessary to enable them to be understood by the witness or person in question. So, use of an intermediary, not just an interpreter in respect of languages, but an intermediary who is able to translate the communication of information from the witness to the parties. And the final special measure is the respective aids to communication. And again, this would be related to the persons who, a category of persons with a physical disability or physical disorder. And a direction may provide for the witness while giving evidence, whether by testimony in court or otherwise, to be provided with such a device as the court considers appropriate to enable questions or answers to be communicated to or by the witness, despite any disability or disorder or other impairment which the witness may have. Now, Section 19 of the Ordinance deals with the status of the evidence, so that it's clear to that however the evidence is given, if it's given by live link or otherwise, that the evidence is given equal weight. And there is provided in Section 20 the requirement for the court to give a warning to the jury. I'll just read it. It says that during a trial on an information with the jury, evidence has been given in accordance with the special measures direction. The judge shall give the jury such warnings, if any, as the judge considers necessary, to ensure that the fact that the direction is given in relation to the witness does not prejudice the accused. So again, it will be apparent that this is a special measure given. Now, in respect of a child witness, it's given because it's a child witness, but in relation to the witness under Section 4, a witness who may feel distress under that category, it is important for the court to make it clear to the jury that the fact that a measure was deployed in respect of this witness because of the assessment of the court that the witness's distress is such as to entitle him or her to have a special measures direction given, that nevertheless, the accused person is not to be adversely impacted by the jury drawing a conclusion that because the special measure was given, therefore, that tends to point towards the guilt or culpability of the accused person in relation to the distress or the fear that the witness may be feeling. And so the courts to be careful in respect of giving the warnings to juries so that the accused is not prejudiced by the use of any of the special measures found in sections 11 to 18 of the Vulnerable Witnesses Ordinance. And that, in fact, brings me to this brief tour of this comprehensive piece of legislation. Are there any questions?
Yes. Hello, good afternoon. I just wish to know if there are any questions, and if you could just indicate by a show of hand.
And I do apologize if I was obscured for a while. I wasn't seeing myself, so I didn't realize that the lighting conditions, it's been stormy most of the day in the Bahamas. And in fact, it was very bright inside, and I was able to be seeing clearly, but apparently it's lightened up on the outside, so that might have caused some shadowing. I do apologize about that. Suppose, as they say, it's all as clear as mud.
Good afternoon, everyone. I don't have a question. I do have a comment, however.
Yes,
May
Judge.
I'm sorry, may I, Adrian Kane, one of the on-island attorneys at the moment. May I ask a quick question, please, about the giving of evidence by vulnerable or child witnesses using pre-recorded video facilities. Is there a code of practice within the Turks and Caicos Islands that underpins and supports this piece of legislation? I say this because we've been doing this in the United Kingdom for about 20 years, and there's quite an extensive code of practice. It's called Achieving Best Evidence, by which the interviewing process is closely monitored and guided. And it not infrequently happens that police officers take witness statements of child and vulnerable witnesses in the context of a pre-recorded interview setting, but there are certain rules that they have to adhere to in conducting the process. And those rules are set out comprehensively in what we describe as the ABE interview protocols. So I was just wondering whether there is a similar protocol here in the Turks and Caicos Islands that underpins the legislation, or whether there's any plan to introduce such a protocol. I've actually looked it up on my computer here while I was listening to Mr. Justice Turner, and I can share part of it if it helps, but just wondering if there is any such provision in this jurisdiction.
No.
Because otherwise you would have a situation of potentially, police officers asking leading questions or making suggestions potentially to witnesses, and all of that is closely guarded in the processes that we have in England and Wales.
And somebody from specifically who has had more experience than I have had in the Turks and Caicos Islands can speak to this, but there is section 53 of the ordinance does indicate that both that an order may be made by the governor, but also that under subsection 2, the power conferred by the chief to the Chief Justice to make rules of court under section 60 in the Supreme Court ordinance is extended to this ordinance, and so rules can be made. And from my research, I haven't seen any rules or other practice or other directions thus far. It's fairly new legislation passed on the 1st of October 2020, and so less than 3 years old. And certainly the 2021 revised statute laws indicate that there's no subsidiary legislation under this ordinance thus far, unless I am factually incorrect. Is that the case?
If I could assist Justice Turner.
Thank you, Justice Jackson.
There are two things. There's no other subsidiary legislation to the vulnerable witness ordinance, but what we do have in place is that sexual offenses are investigated by a special unit and that within that unit, the officers are trained to do ABEs. They know what questions to ask. They follow rules along the similar lines, which you will find in the UK. So you would not have improper questions being asked, and therefore the ABE can be used under Section 15 of the Vulnerable Witness Ordinance and has been used in the Turks and Caicos Islands at least once. And so to answer the question of Mr. Kane, there are no subsidiary legislations, but the similar rules are followed as in the UK, so that the ABE is a sanitized document which can be presented in court as evidence in chief.
Thank you very much, Justice Lovin Jackson. Thank you also very much, Mr. Justice Turner. So would it be right to say then, for those practicing in the TCI, and I only have limited admission here, so it won't involve me personally, but is it right then that the Achieving Best Evidence memorandum from the United Kingdom is something that could be relied upon and drawn to judges' attention here in relation to any cases where an application might be made for a pre-recorded video of a child or vulnerable witness's evidence to be given as their evidence in chief? And would that be taken into account as part of the admissibility process if admissibility is challenged?
I think certainly in respect of if a type of document were to be used, I don't see that it could be, well, if it's challenge, it's a practice which has history and has been proven in its development to be of assistance in ensuring that, in fact, the evidence is properly receivable. The court has to make a decision as to whether it would receive the examination in chief, the video recording, or whether it exclude any part of it. And if the guidelines prevented any part of it from being excluded, then the evidence which is receivable under the ordinance should be able to be received. That would be my estimation of that.
Yes, thank you very much again, Mr. Justice Turner. Thank you very much, everybody.
Thank you, Justice Turner, for that comprehensive review. I had a brief comment just to indicate that the Section 14, the removal of wigs and gowns, have been used in the Turks and Caicos Islands more than once, including by myself. The video recorded evidence in chief, as mentioned before, the ABE, has been used in the Turks and Caicos Islands by former Justice Aziz, and the Section 17 examination of a witness through an intermediary has been used by myself.
Thank you. Could I also ask whether, has there been a trial in the Turks and Caicos Islands as yet using an anonymous witness?
There is one. There is one on the list now. There is a murder case for which a witness anonymity order has been made. Trial date is to be scheduled shortly, so an order has been made, but the case has not yet come to trial.
And the protocol would be that in respect of that witness, the witness would be physically in the courtroom but screened and voice modulated?
It depends on what was stipulated by the order, but the actual how the order will be executed, so to speak, all of that will be decided before the hearing date, whether or not it will be voice modulation, it will be outside the room via link, or it will be a screen. So those fine details have not yet been determined, but there is an order in place in relation to 2 of the primary witnesses.
Very well. Our experience has been that in respect of the voice modulation and being outside of the courtroom, that it's more easily done outside of the courtroom, because again, in small courtrooms or even in larger courtrooms, sound may carry. And so in terms of the modulation, you have to be very careful as to how that's, if the witness is screened but in the courtroom, as to how the voice is going to be modulated to be projected into the rest of the courtroom, then the natural voice may also be projected into the rest of the courtroom. And so we have done anonymous witness trials with the witness both being in the courtroom, but more frequently with the witness appearing behind a screen from a remote location with voice modulation. And then, of course, we have to be very careful with the technology because we had the experience with voice modulation of the modulation dropping and the natural voice coming through, which again, in small societies can be fairly dangerous because the witness may very well be identified by a few seconds of his or her voice being broadcast into the courtroom in the presence of the defendant. And so those are all matters which have to be looked at very carefully. We're in the process of seeking to set up a courtroom in which, because there's varying views as to the scope of our legislation. And so we want to have a courtroom in which we're able to have individual screens for each of the jurors and for the judge with headsets so that the jury and the judge is able to see and to hear the natural voice of the witness, but projected into the courtroom would be the modulated voice of the witness appearing behind a screen. We will be working on it and we will see how it comes to pass. We haven't done such a trial though with the jury and the judge seeing the anonymous witness.
This is why this presentation is so timely, because there's actually a case which is coming up very shortly for trial in which two anonymous witnesses to an alleged murder will be presented. And due to the COVID-19 measures which we've had to take, the courtrooms are equipped with a certain amount of technology which would allow what you're suggesting to take place. But until we actually try it, we won't know how successful we are.
Yes, the devil is often in the details as to how it actually comes to pass. So wish you all the best for just in terms
Thank you.
of how it works.
Thank you very much.
And I'm just now seeing the Mr. Justice Adderley on the call. I should have acknowledged you as well, Mr. Justice of Appeal Adderley. Good afternoon.
Good afternoon again. I am just inquiring whether there are any other questions.
Good afternoon.
Good afternoon, Dr. Sophie Turner. Good afternoon, attendees. My name is Mikia Mills. I am a member of the Office of the DPP here in Turks and Caicos. I just wanted to make a comment in respect of the question asked of the number of matters that we did have tried here in respect of vulnerable witnesses and anonymity orders. There was one case tried by Justice Aziz, former Justice Aziz, where the main witness was anonymized. However, that was done prior to the vulnerable witness ordinance coming into effect. And so the Court of Appeal did overturn that conviction on the basis that the court did not have the jurisdiction to make such an order. And there were also some shortcomings in respect of how the disclosure obligations were met by the Crown in accordance with the best practices in respect of cases such as Davies and other cases of the extent to which the Crown should have gone in respect of its disclosure to ensure that the trial was a fair trial. So I just wanted to bring that to everyone's attention. The Court of Appeal decision of Regina against Kendall Dean against Regina.
So I could have that name again?
Kendall Dean.
Kendall Dean. Thank you.
ALLDEAN.
Thank you.
Yes, my lord.
I am just checking whether there were any other hands, or are there any further questions, please?
Ms. Kimball, I just want to double check
Okay,
something.
counsel.
Yes. I'll be 1 second, please. Let me. Here I am. Afternoon, everyone. Good afternoon, especially to you, Justice Turner. Nice to make your acquaintance, although from afar.
Good afternoon.
Right. I thought I heard correctly. I just wanted to double check. There are no regulations in place accompanying the statute as yet.
Certainly none that I think it's been confirmed, but I certainly didn't find any, and the act itself says as much.
Right. I thought I heard too during the introduction by the registrar that you left the Normal Manley Law School in 1987.
Yes.
I see. That's just before I entered, so you kind of pass on the baton. But there's a equivalent Jamaican legislation. I think it's somewhere about 2011, 2012. Some very interesting cases have been decided since the passage of that legislation, which perhaps I heard counsel speak to a decision from this jurisdiction. But listening to you, I recall there's an interesting case in Jamaica from 2017. Don't know if you're aware of it. The Queen against Christopher Thomas. In fact, the witness in that case was 14 years old, and the statute was prayed in aid to have that witness give evidence by video link. A young lady of whom it was said she began to shake uncontrollably every time she saw the defendant. In fact, I think she had given evidence at the preliminary inquiry, but they wanted her to give evidence by video link at the trial. I thought it's a decision which could be of some guidance, interestingly, because of how the court looked at the provisions of the statute, and also in terms of how the court, of course, resisted defense counsel's application and allowed the application from the DPP's office. But I wondered, in terms of regulations, what the question I'm posing to you directly, apart from that comment on the Queen against Christopher Thomas, is to what extent do you think there could be provision in such regulations, subsidiary legislation for to circumscribe the area in which a witness is to give evidence, particularly somebody who's giving evidence from very far from the court? From your experience, or in terms of your suggestions, what are some of the provisions which could be made in such legislation?
So we have regulations in respect of subsidiary legislation, I should say, in respect of video link applications. Now, they don't go into the detail as to where, but they do generally require that the location in which the person is to be testifying from should be able to be, you should be able to see, for instance, in terms of the camera equipment, that you're able to see that the person is in a room by themselves, so that the camera system at the location where the witness is testifying has to be not just a stationary camera, but a swivel camera, a 360 camera that they refer to it, which is able to be controlled by the court, so that the court of its own motion can check the room by having the camera scan the room and to determine whether there's anybody else present in the courtroom. In the space, in the physical space in which the witness is testifying. Now, we, however, and we do have locations, for instance, in which witnesses, because we use video links constantly. And so in just about every trial now, there's at least one witness. And of course, the Bahamas, to some extent, like the Turks and Caicos Islands, is an archipelagic jurisdiction. So we have a number of islands which witnesses are all over the island. And interestingly, one of the reasons that you can make a video link application has to do with expense. So here's a person who's on a family island who has a small part to play in a matter, and rather than going to the expense of bringing that witness to New Providence, that witness can testify by way of a video link. we have defendants on family hours. And so rather than them coming in for a case management or the hearing, they either on their cell phones or on their, or they go to the court if they don't have a smartphone, as we refer to it, so that they can appear in the court without coming and spending the money to come to Nassau. But we've also had witnesses testify. I did a murder trial in which a witness testified off of his phone, and he was the principal witness to the murder. In fact, he was shot in a car and immediately left the Bahamas, and he testified from someplace in Canada, which is, as he described it when we were asked, where was he physically at the time as he was about to testify? He indicated someplace in Canada. You all know Canada is a very large country. But he testified from his car. We had him scan the car to see that there was nobody else inside of the car before he testified. So he didn't require that he be in something which approximated a courtroom, because we're trying to make this as easy as possible on witnesses once we're able to be satisfied that the conditions are such that the witness is testifying and it's not being prompted or aided by anything else, by a note or by a statement in front of him without asking for leave to refer to it, or by a person prompting the witness. So whichever technology we use, we satisfy ourselves on that, and then we act on it. But when they are testifying from, as an anonymous witness, for instance, most of our anonymous witnesses testify from outside of the courtroom. There is a facility, and within the facility, you're able to see that there is a screen, the witness is behind the screen, but you can scan the rest of the room. And you can do so at a time when the witness may not be expecting it, so that there can be nobody out of the camera sight, because the camera can move and the court can control it. So the technology would not be the sort of simplest technology. It's a more expensive camera with the remote control, but that's required so that the court can satisfy as to the witness being not being prompted, in particular when they're anonymous witnesses and the accuser is already limited in his ability to cross-examine that witness because of the anonymity. You see, there's another hand as well.
Thank you.
Thank you.
Was there another hand that was up?
Yeah, oh no, my hand is up. So
Oh,
I was just
okay.
waiting for you to recognize me before I get behind, ahead of myself. Sorry.
Forgive me, King's Counsel. I am not the best with the technology. Please go ahead.
Okay, thank you, Your Honor. Good afternoon, everyone, and my lords, we are grateful that you delivered so eminently this afternoon on a piece of legislation that we are still trying out, just beginning, if you like. It was passed in 2020, just as we are smarting out of the COVID-19. And it came together with the Sexual Offences Ordinance as well. So we are still trying it out, but I want to commend my lady, the Chief Justice, the defense, as well as my officers and the judiciary generally, the way we've moved on in terms of endeavoring to give practical effect to these new ordinances in the absence of what you may call subsidiary legislation. But in place of that, my lady, the Chief Justice, had formulated and published regularly practice directions going through the COVID period, and embracing and covering quite a number of the challenges that we would ordinarily face when you are in small islands and with the COVID. And so we, just as I think as recently as last 2 weeks or so, another practice direction came out that now enables the witnesses to give evidence from the courts in providencialis, while the main court is in Grantock, because cannot allow persons in custody to be traveling between the islands. And that has assisted in the participants being in one place and then beaming into the court and with the accused persons present with the judge in Grantock. So one way or the other, my Lord, we've tried to respond to the challenges we are faced with in terms of small islands and multi-islands. But in relation to this ordinance in particular, we've also tried, as my Lord, my Lady, the Justice Loveland Jackson had indicated, we have current matters that may require, in fact, orders have been made, anonymity order has been made. What I am worried about, my Lord, is the small nature of the islands. I think you made allusion to that in relation to anonymity. You will be in a comfortable position where the anonymity is real, because the person is not known. Indeed, you are comfortable that that is so. But as a prosecutor and as the defense and as the judiciary try to manage the anonymity challenge in small islands, you are wondering the utility of it in instances where something is telling you that persons are already aware of that person. And so in the course of proceedings, for example, you've had defense almost pushing to the point where you will run the risk of disclosing the identity of such a person. So in totality then, I'm wondering what your experience and challenge, what they are in the Bahamas. I mean, you are bigger than us in several ways, but we have small islands, and it is a problem. It is not the kind of problem that UK will face or United States will face, but it is a unique one, and it relates to our size. And so I'm wondering whether I think it was Adrian. Adrian, you spoke about the supporting documentation protocols and how that applies in UK. We could use all of that as a guide subject to local circumstances, but our own unique nature is that we are too small to even endeavor to hide somebody. And my Lord, when that order is got, on the practical side, you are also trying to protect that witness. It's not just that it's anonymous, but you are on the ground trying to protect that witness. And in the course of doing that, you will find out, of course, it is within the purview mostly of the police, but because they communicate with us as it should be, you are worried that the efforts they are making to protect the person, it's discomforting, because you could see that they are grappling with it, and it's quite difficult. So I just want to find out your own experience in the Bahamas. The other question I wanted to raise is the video recorded examination in chief. You had indicated that it's not been tried in the Bahamas. Is there any reason why they have not adopted what I consider to be quite a convenient way of preventing particularly victims of sexual offenses from being exposed continually to the trauma of examination in chief?
Thank you for those questions, Mr. Director of Public Prosecutions. I'll answer the last one first. In respect of sexual offenses, we are in the process of seeking to set up a specialized sexual offenses court in court so that we can deal with sexual offenses with specialized training, specialized facilities, and hopefully expedite the passage of these matters through the criminal justice system much more expeditiously than is presently taking place. My analysis of the matters which are being filed, because I do all of the arraignments in the Supreme Court, is that 1/3 of our matters, 1/3 are sexual offenses related charges in the Supreme Court, persons being brought for trial in the Supreme Court. And so specialized court, when we have 9 judges hearing criminal matters exclusively, if you had one specialized court, actually might result in delays. And so you need to set up a specialized set of courts to hear these matters. And then as we get into that, then in terms of the training for the police officers so that they can take proper statements and which can be used as evidence in chief, video recorded. I think it was in fact tried once, but it has not been in fact presented in court. We do know that one was done, but it has not been presented in court. The reasons for that are best answered really by the police. They do have a specialized unit. They have protocols in respect of the investigation and treatment of alleged victims of sexual offenses. Try not to refer to persons as victims until that's been determined by judicial consideration of the matter. But in particular, if it's a consent assertion. And so the police will need to answer on that issue. In relation to the issue of witness anonymity orders, again, we say that the Bahamas is large in the Turks and Caicos Islands, but my friends in Jamaica would still refer to the Bahamas as, and to us in the Bahamas as small island people. It's just 400,000 Bahamians, maybe 55% of that being to 60% being in New Providence. Everywhere else has progressively much less, after Grand Bahama in particular. But even with that, the reality is that except in the instance in which there just a witness happens to identify a person, and I've said this often, that really anonymous witness legislation works when it's the person driving by a bank as the bank robber runs out and takes off his mask. And the person drives by, sees the person with the gun in his hand, a bag of money, and he took off his mask getting into a car, and he's able to identify that person. So the bank robber has no idea who it is, who has identified him. Just a car that was passing, and the person says, I was driving past the bank, I saw this. But when you have a situation which is a killing or homicide in a community, only so many people were around at the time, it is always a very limited number of persons, and it's not long at all before people are able to, as they say, suss out who it is, provided the information to the police authorities. And they do their own inquiries, and the information is revealed fairly quickly. Added to that is that it is a very particular and careful exercise to move a statement, an unredacted statement, so that the court can see it, to the court, and ensure that it is not accidentally or deliberately revealed, because all of these files pass through a number of hands. You have to put in place a very particular set of rules and procedures so that, in particular, those unredacted statements go to very, very few people. Once they pass to more than 2 hands, then a photocopier is nearby. Once a copy of it is made, that's the end of it. It's going to be out there, and within a day, the defendant is going to know who this anonymous witness is. So it is very difficult, in fact, and really this type of legislation, only in very particular circumstances can it be effectively used. But if it's a community killing, a community homicide, an alleged murder, in most instances, the person is going to be able to be identified even if the name isn't given. And that has been our experience. What we need more than anonymous witnesses, because it's a cheaper method for the police, or they could tell the witness, well, nobody will know who you are. It's cheaper than having to provide witness protection. We have witness protection legislation as well, but the experience has been that witness protection is expensive, in particular if it takes a long time for the matter to get to trial. Then after a period of time, the person gets cabin fever and starts to move out and stops complying with the protocols that they're put under in order to be a part of the witness protection program. They have to agree to a certain number of things, and most persons can do it for a few weeks, maybe for a few months. But anything over 6 to 9 months and going on years, it's not going to work. They're going to leave the program, and that's been our experience as well.
Thank you.
Dr. Adley, see your hand was up.
Justice Adderley?
Oh, yes. Thank you very much. I don't have a question. I would just like to take this opportunity to welcome Mr. Justice Turner to the Court of Appeal and to thank him for what I found to be a very instructive presentation and very thorough. And also I wanted to thank the Honorable Chief Justice Ajiman and her staff for the choice of such an appropriate topic at this time. So I just wanted to take this opportunity, Mr. Justice Turner, to welcome you.
Thank you, Mr. Justice Adderley. I do appreciate that.
I had a look and I note that that was the last hand up. So it remains for me to give the vote of thanks. What has been quite a pleasant afternoon. So good afternoon, everyone. I adopt the protocol established by the learned registrar of the Supreme Court. Feeling gratitude and not expressing it is like wrapping a present and not giving it. William Arthur Ward. It is my pleasure and privilege on behalf of all of us to extend heartfelt gratitude to the persons who made this event possible. I say thanks to the Honorable Chief Justice and the Judicial Education Institute of the Turks and Caicos Islands for seeing it fit to host this most timely lecture. I thank our presenter, Mr. Justice Bernard Turner, Justice of Appeal of the Turks and Caicos Islands, for a most enlightening and thorough presentation, which gave us a lot of food for thought on how best we can utilize this fairly new piece of legislation in the interests of justice. Last but not least, I thank the attendees this afternoon for their rapt attention and participation. I end with a quote from H.A. Ironside. We would worry less if we praise more. Thanksgiving is the enemy of discontent and dissatisfaction. Before I end, I wish to inform everyone that the JEI will be circulating a short anonymous feedback survey shortly. We would really appreciate if each participant completes this survey. Ladies and gentlemen, I thank you and do have a good rest of afternoon. Take care and enjoy your weekend. Thank you.
Good afternoon.
Afternoon, colleagues.
You're